being the deadline to evict me. And if I do not vacate the property in question, which is recorded in my name, tomorrow to their machinery, they will evict me. I'm seeking for dispensation of Rule 26 because in a writ 48 hours is a mandate. Dispensation can be always sought for demonstrating extreme urgency. If not grants leave, I'll get it affirmed.
Is the matter in the list? No.
No, it's leave to bring within the list. No.
It was a senior.
Any court I already my lord of stat. I am sorry.
You moved, you will accept it.
I want to do this matter before my lord has it because I have some already matter is going on. A Chokidar matter. It's something that only. Anyway, my lord, I'll let me.
Any mention of the my lord, I want to mention one matter, my lord. It's a kind of matter, my lord. Passed by Honorable Justice Nizamuddin, since Honorable Justice has retired, my lord, the matter has to be come up on list. I pray that it may be bring it on list. Usually,
I think. When it comes to,
Yes.
you move before the senior bench.
any mention in the list? Item 1, CO 2 of 125.
Now for the petition.
Well, in this case, copy.
Civil division right of audience, my lord knows, and unless until which court directs, they have no right of audience. Oh, caveat, I have not received any caveat.
Oh, caveat has been filed. Mr. Jaipal, caveat has been
No,
filed.
I'm bound to serve it. I'm bound to serve it. No, you have not given me. I might be put notice on that you have filed the caveat. It's not. I'm not a magician. I've not received it, brother. I've not received it. I'm not a magician that I come to know that it has been filed there. You have brought the notice to the court. I'm giving the copy. That's it.
That being so.
Have you served a notice upon them?
No, nothing has been
I have
served.
already
As
posted
per-
through SP no,
When have you
through the
filed?
client.
When have you filed?
I have filed, I think, first of this week, this month. Maybe,
3rd of January.
yes, my lord.
Today is 14th.
Yes.
Not received.
Just to eliminate this dispute.
Yes, what will you What will you submit?
I am appearing for the Calcutta Municipal Council because in the trial court I was appeared. If the other side is serving copy to the respondent number 3, let a copy be given to me.
You are representing private respondent.
Yes, sir, private respondent number 3. I am for 1 and 2, I appeared before the trial court.
3. You are representing 1 and 2.
1 and 2, Calcutta Municipal Council.
So learn.
I'll get.
Figure it out, representing the private respondent. Respondent number 3. Private respondent. Submits that caveat has been filed. This has been filed. A notice has been sent to the petitioner. In the trial court, you were the
Plaintiff. petition.
Plaintiff, petitioner plaintiff. Plaintiff, full stop. अच्छा, the opposite party number 1 and 2 are also
Okay, I'm occupying there, I'm residing in a dwelling house, very small space of room with my handicapped son. The council, this request passes an order at the first instance, holding that the structure where I'm residing is in a dilapidated condition that needs to be pulled down. There is a provision under the municipal regulation. That order was challenged in a writ proceeding. During the pendency, I was given liberty to effect repairs, minor repairs. I carried out the repairs. A report was submitted before the writ court. The writ court relegated the matter to the council. Since report has come, you just inspect once again to see whether the condition, how the condition is. When the matter was relegated back, they again passed the same order for pulling down my dwelling house under the same provision. For the second time, writ court was approached. That order was not interfered with by the writ court, but an interim protection was granted to me for a period of 15 days. That dismantling order would remain stay. You file a suit against that gentleman, OP number 3. I filed a suit for permanent injunction before the trial court with a prayer for effecting repairs. It's at the very initial stage. Along with the suit, an injunction application was filed saying that can you protect my possession over the suit, and since I'm residing there and it's a matter of trial to be gone into, even the order of dismantling is under challenge before a civil court.
the defendants, the defendants of the council and the secretary of the council.
Council.
Pro forma, the private, he is the pro forma defendant.
Pro forma because his name, the property is recorded. His name, the property is recorded.
You had claimed an injunction against 1 and 2. Defendant number 1 and 2.
Again. And against all.
That's against.
Against all. Trial court
He has
refused.
nothing to do. He has told you.
But he is a troubleshooter. At his instance, the council have set the proceeding in motion.
That that is an apprehension.
My lord. So, lordship, when the trial court refused my ad interim prayer, first appellate court affirmed the order of rejection. Now I'm before this court. I'm occupying the land, I'm in possession of the land, they've admitted this position.
Against injunction, you have come up for a revision.
No, first I approached the district judge.
Again, rejection of.
Order 43 appeal was preferred before the district judge. District judge dismissed my appeal. Then now civil revision. Order 43 was invoked, lordship.
Herein, first of all,
Service has not.
that council hearing, first of all, the maintainability will have to be,
Civil division.
no,
It's
will have to be shown
Yes.
thereafter.
Mal.
Thereafter, we'll go into the hearing
Maintainability to maintain the application.
under civil revision.
Mal.
Item 3, CRI 22/24. Item 4, CRI 23/24. Item 5, CRI 24/2024.
So discuss.
Item 6, CRI 25/2024. Item 7, CRI 26/2024. Item 8, CRI 27 of 2024. Item 9, CRI 28 of 2024. Item 10, CRI 29 of 2024. Item 11.
Lord, item, we are appealing to the respondent, there is that, Lord, regarding that fruit vendor shop.
That one is
Petitioner has
item,
requested it. should
that
be
one is item number 11.
11. It will not today because the other side.
today.
Because my lord has already heard it. The appearance of the respondent will be recorded.
Not today.
Item 12, WK.
Lord, this my lord has directed me to file the affidavits. I have filed my affidavit in the registry, my lord.
Affidavit of service.
No, my lord, opposition.
Opposition.
The rate is not maintainable, my lord. If my lord is fixing it tomorrow. I can.
Which one?
Item 12.
12. Each and every matter will be not today.
Yes, yes.
Item 12. Who is representing the petitioner? Nobody is representing the petitioner now.
Rent name.
Item 13, WK 689 of 2024.
I'm for the respondent, my lord.
Hmm. Yes.
This is that matter that private respondent has not been served. Yesterday that matter was heard.
Who is for the petitioner?
Let it be not today.
Item 14, WK 714 of 24. Item 15, WK 524 of 24.
Lordship, my senior Miss A. Zino is appearing for the respondents. I have
Okay,
filed
15.
my for 14, item 14.
Item 15,
Appearing for the superintending engineer and others.
Lordship,
Nobody is representing the petitioner.
let it be not today, Lordship.
Today, not today.
item 16.
16 also.
16 also, not today.
Obliged, Lordship.
1 minute. Ready for hearing?
Last time the respondent was directed to file affidavit in opposition.
Let it come tomorrow, Lordship. Tomorrow I will file it. Because today is the holiday for the officers, Lordship. Because local administration is on leave today.
You will be able to file the affidavit in opposition tomorrow?
Yes, Lordship. Yes.
So the matter can be taken up tomorrow,
Yes.
not today.
Obliged, Lordship.
Item 17, WK 113.
I appear for respondent 4 and 5. Okay.
Just not today. Not today.
Item 18, WK 546 of 2024.
My lord, I would be appearing on behalf of the respondent. My lord, I have filed my affidavit in opposition before the registry. My lord, to see whether it has come or not. It has come. If it's come, my lord, let it be recorded. My lord, I have filed my opposition. Let that be in order to that
If the
extent.
petitioner is not there,
Since only my opposition is on record, my lord, I have already
the
filed. my
presence is
opposition.
required.
Presence is required. my lord.
The item number 18.
18, my lord.
Item number 18.
नहीं पहले से नहीं
You are representing both the respondents.
Yes, madam.
Um,
I filed my affidavit of opposition on behalf of both the respondents.
Name. Name.
18.
Item number 18. The affidavit, isn't it? Without parking. As there is revision bullet or
Item 19 WPA 510 of 2024.
My lord, I am for the respondents, my lord. In this matter also, I have filed my opposition before the registry. Has to be seen whether it has come. Same order will pass to
19, same order, 19.
Lordship, objection.
Item 20 WPA 475 of 2024. And I am for the issues.
I am for respondent number 1, my lord.
Hmm.
There is a, huh?
My senior Miss A is is appearing for the private respondent.
Here for the official response.
Municipal.
What is your prayer? What is
Lordship,
your
I'm
prayer?
praying for not today, Your Lordship.
You are representing respondent number 1, you are representing respondent number 3. You are representing respondent number
Private
4.
respondent, Your Lordship.
4. What about respondent number 2?
2 and 3.
First, we are paying for 2 and 3.
2 and 3.
Hmm.
2 and 3.
Both the Port Blair Municipal Council and the executive engineer.
I am for respondent number 1, my lord.
One.
And they are for the added respondent, respondent number 12. Subsequently, they have been added.
Oh, okay. Lord Council, to that effect, there is no endorsement. That the respondent number 4, yes, in the first title.
We granted
It was, I think, leave had been granted earlier.
I'll do it.
1 minute. When the Razina Kajur is impeached as a party respondent in the writ application. Learned advocate for the respondent number 1 and learned advocate for the respondent 2 and 3 submit the writ petition in the order of commission has already prepared. Considering the facts of the case, it is reviewed that the matter cannot be decided without following the affidavits. Hence, affidavit in opposition may be filed within 2 weeks. Affidavit in opposition filed.
Just not today, but check it whether it is reported.
You are representing 1 and 2.
2 and 3.
2 and 3. Your affidavit in opposition has been filed.
No, no. I'll not be filing because contesting.
Not be filing.
2 and 3.
Affidavit opposition.
Lordship, I'm not having the brief. I don't have any.
No, 2 affidavits. One on behalf of respondent number 4 and on behalf of
2 and 3.
2 and 3.
So,
So, and you won't be filing.
no. Okay.
Private secretary is pending after the deputy commissioner of data things to put up from 10 to 24. The point of the expectation that the has get to have current numbers 1 and 4 and 3 are permitted to proceed in a but no force for the taking as the appeal is pending before the deputy commissioner. And court does not restrain the deputy commissioner to proceed with the appeal and the petitioner has also the opportunity to appear with the deputy commissioner. Part of the was. Okay, so on the prayer of the
If they, I can correct.
Name,
Rank done.
the learned counsel. The learned counsel representing the petitioner. Total last check of the date. Date. Yes.
Item 21, WPF 4, 37 of 2024.
My lord, I appear on behalf of respondent 1 and 2, my lord, official respondents.
I'm for respondent number 3.
It's not.
Let it be not to be.
Any order required?
My presence will be recorded.
That you submit. On the prayer, item number 21.
21.
On the prayer of the learned counsel.
Item 22, WPF 417 of 2024.
They are appearing for the respondent, my lord.
Chief Secretary. Yes. Any other?
But I think the Union of India AG is appearing in this matter. I'm not sure. If the petitioner is not there, well, let it be not today. And appearance may be recorded.
the name of. Anil. Um, You are representing the chief secretary, the secretary labor, all the respondents.
For the Andaman Public Works Department, I am appearing on.
Okay, you are representing respondent number 4.
Yes.
So you are representing respondents number 1, 2, and 3. Yes. Name one of the name. Item number 22. Item number 22. One of the nominee.
Twenty-three, WK 341 of 2024.
I for respondents.
Mercy is appearing under the petitioner, my lord, just not today.
Appearance, the respondents are. Appearance, appearance, on the prayer of the Lord, advocate representing.
Pay for the respondent.
Council,
Not sure. The respondents, we don't know what it is. Thank you.
you are having a.
No, naam hai bhaiya. We
Not-
are not appearing. Only the AS Jinu is appearing for the respondent.
Have you been served upon the Union of India, Lord Council? So you know.
देखने के लिए कोई
Huh?
क्या भी है.
You are for the respondent.
That is affected your logic.
हम लोग तो नहीं है इसमें. हम लोग नहीं है.
Hmm. You are for him.
Respondents.
Airports.
Records not. And for the respondents, all the respondents.
Not all the respondents.
Except respondent number 1 for all the respondents.
You are representing the Chairman Airports Authority of India.
The senior
You represent your senior, you are representing. The Executive Director, Airports Authority of India. Regional Executive Director, Airport Authority of India, and the Airport Director, Airport Authority of India. Name. In that one. Only not today.
Item 25.
On item number 25, my lord, we record to find the reply. It is not yet ready. We require some more time.
Lord, we are appearing
So,
Yes,
let it
sir.
be
Appealing
next-
for the
Next circuit.
respondent, my lord, reply has not been filed.
Yes,
They want to file reply, my lord.
Next circuit.
Reply, my lord.
Next circuit. Next circuit.
Reply के direction नहीं चाहिए.
already have.
Circuit.
But without extension, my lord, without extension, my
Already
lord,
have submitted. Both the other.
extension में भी कर दो.
Council. At least the mobile be.
Sorry, my lord. My apologies.
The other advocate representing the petitioner.
Friends.
Defense.
For the respondents, I am appealing.
Petitioner is not there.
Not there.
The respondents are being represented. The respondent.
Item 27, SAT 2 of
Right. But through department, the paper book has been served to respondent. I've been asked to put requests before the registry. 2 days ago. By the school. Already paper book was prepared by the registry and it has been duly served to the.
1 minute. First of
It's not.
First of all, what is the substantial question of law? Seeking today's accommodation,
Yes, yes,
only for today.
yes.
What is the substantial law?
The division bench, my lord, I'll just draw my lords to that. Order at, my lord, find at page 118 of the paper book, 118. While admitting the second appeal, only one question has been formulated. But section 105 is always available, my lordship. If this court finds,
That is, at the time of hearing, if
yes, absolutely, absolutely, my lord. Absolutely.
if it crops up that a further substantial question of law is required to be framed, that can be.
Absolutely.
Whether the first appellate court erred in law in misreading and misinterpreting the documentary evidence marked as exhibit 3 small g, which was a local investigation report and the oral evidence of PW2. Santosh Prakash, while affirming the findings returned by the learned trial court in adjudicating the issues number 2, 4, and 5. It is ready for hearing.
Yes. This can be even taken up and it can be disposed of during this.
So, let the matter, the learned advocate representing the
Because we are almost at the back end of the circuit. If the matter retained its position in the list, second appeal it will take time. If not upgrades it to some because it's, one question has been formulated. 105 or those things are come later on, not during course of hearing. Really? And this is otherwise ready for hearing.
Mr. Bokshi. Hi. Essay 24. Number 27.
27.
You have filed Wakalandam?
Not
With
yet,
the
my lord.
department, huh?
Not yet, my lord.
अपना नाम कर दीजिएगा Mr. Learned Advocate. Okay. Your name, Learned Advocate, is representing the respondent and submits that he will file Wakalatnama on. Hey, you don't have the
Or else by
Wakalatnama?
today by evening I'll file.
File the Wakalatnama during the course of this day. During the course of this day. As such, representation as regards to the respondent complete. The paper book has already been prepared. So why it has not been renumbered? No, still now SAT.
Essay, now tender has to go. It has to be essay.
Something 97 upon 21.
Sir, I am appearing. Sir, this matter may be fixed in the next circuit. Actually, sir, I didn't got time to prepare. This is a 2021 matter. This has been listed recently. I have filed this petition in the year 2021. And
Well, have you deposited the court fees?
yes, sir, I have deposited the court fee.
I have deposited the court fees.
Yes, sir.
Has been deposited. The effect Fine, document be kept in the record. Fine. It is a document be kept in the record. Stop. Paragraph. The petitioner. Matter before the next circuit bench.
Yes, sir. Thank you.
Consider the prayer of the petitioner. Let the matter appear in matter mentioned for the next circuit bench. Next circuit bench.
Thank you.
Item 29, essay 7 of 2024.
Not even this matter, I prepared the paper who not can recollect. This is that matter.
That husband and wife.
Yes, that's the one. That's the one.
The earlier matter will take, it won't take much time, the earlier matter.
No.
And this one,
Same lawsuit, paper publication has been made by the wife in the newspaper.
oh, so this one.
Contempt to tarnishing the reputation of the husband. Suit for
That
damage
is
of file.
Thursday, Friday. If cooperated, the matters can be heard.
No.
Are you ready? Not ready means not now. Is your senior ready?
Can I say one thing?
Hmm.
Madam he can always jot down the points. I will start today. So far as this second appeal is concerned. If it all takes tomorrow, day after, I'm not sure. I don't know what is going on. I will start. Madam can be, even Madam was agreeable on that day. She will not have any-
You take instruction.
Already take, got that instruction that matter when we put it on tomorrow.
Then Mr. Jaipal will submit. You will take note of his submission. Nothing more than that.
And then I go.
You take instruction.
Fine.
And apprise the court.
Password will be given.
Hmm?
Then short password will be given, I'll take instruction.
Which-
The other three matter may be called so that pass over, it can be, we can. Can we take the hearing, it will take quite long time.
No, very short. Short years.
Who-
Filed.
Yeah.
Files. Opposition file. Already on before.
And others. Andaman Nicobar Administration and others.
For all the respondents, one,
You are
2, 3 and
representing all the respondents.
1, 2, 3 and 4.
Four
For 5,
four
Mr.
respondents are there.
5, Mr. Nadeem Khan is there. Private respondent is there.
Private respondents.
Mr. Khan appears on the respond number of 5 being private respondent.
I pay for 1, 2 and 4, 3 and 4.
Mr. N.A. Khan.
No, I have to use my reply as against the opposition.
Affidavit in opposition filed.
Yes,
Yes,
filing.
both of them filed. Private respondent also filed, official respondent also filed.
The learned counsel. Yes, my lord. Here, my lord, election, my lord, to the
Regarding election,
election, my lord. Petitioner advocate is not there.
has it not become infructuous?
Infructuous, yes, my lord, because the but of course they will say it is not. They will say all the acts are illegal.
Same order as that of 31. If you want, same order.
Much obliged.
Yes, Senate Council.
Yes, madam. You can
You can
start.
proceed.
Yes.
Personal matter, that's it. 7/2020.
Well, just first of all,
Affirmation,
it's a reversal.
reversal.
The suit was dismissed. The first appellate court reversed the trial court's judgment because I'm the defendant. The damager was claim against me. Defendant is before this court, in the present second appellate. page 13, paragraph 14.
Hmm.
I'll start with second line. No yardstick has been adopted in the plain to seek compensation to the extent of 50 lakhs as alleged in the shape of damages against the defendant one. The present suit is nothing but abuse of process of law. On these defense, I have sought for dismissal of suit.
So no yardstick has been adopted in the plan to seek compensation to the extent of 50 lakhs. And the present suit is nothing but abuse of the process of law.
No, the trial court judgment, may I draw loss to the trial court judgment or may I take loss to the evidence part?
Evidence.
Evidence. Evidence starts, issues my lord have looked into at page 26. As much as 7 issues were framed by the court. And my lord, evidence starts at page 27. Chief of PW1 being plaintiff is in 2 new plain case. I'll take loss to the cross examination of PW1. At page 39
Yes.
of the paper book, it is a fact that a decree of divorce granted by the learned district judge in my favor was set aside by the Honorable High Court. It is a fact that challenging the said decision of the Honorable High Court, I have preferred an appeal before the apex court. It is a fact before the Honorable Supreme Court, I filed an application for permission to use the Daily Telegram dated 3/12/2008 and 5/12/2008 as supplementary evidence. Not a fact that due to such publication in the Daily Telegram, my honor was not damaged. I filed one case against municipal department earlier, and at present another case is pending against them. Not a fact that the contents of article published in the Daily Telegram on 3/12/2008 and 5/12/2008 were true. It is a fact that a lady named Devi is working under me for the last 6 years. Not a fact that I'm not a respected in the society. Not a fact that I was suspended once in my service. The case filed against the municipal authority were in connection with my service regarding my seniority and promotion respectively. I shall examine one Mohammed Rafi, Mr. B. Hari and Stanley James as my witnesses. I may examine other persons also if so required. Not a fact that my claim is a bogus one or that I'm not entitled to have a degree for 50 lakhs or that due to such publication in the newspaper, my reputation was not injured in the public. I did not file any criminal case in connection with the defamatory matter. Not a fact that my suit cannot stand or that I am entitled to have a degree of interest as per trade. Not a fact that the amount I claimed is excessive one or that I have filed this suit just to harass the defendant or that the suit is liable to be. This is cross-examination of PW1. Then I'll draw lots to the evidence of PW2 at page 41. One Mr. Stanley James.
Yes.
All right. I'll just read it, Lord. From paragraph 3 at page 41 of the paper book. It says, I say that I came across in an article in newspaper, namely the Daily Telegram on 3/12/2008.
This person used to work
With the plaintiff in the Port Blair Municipal Council.
Port Blair Municipal
Yes,
Council.
he's a colleague. The plaintiff is trying to, wherein it has stated that the plaintiff is trying to marry another girl in contrary to law, and if such marriage is conducted, the same shall be illegal and unlawful. I say that earlier I used to have very high thinking about the plaintiff. After going through the contents of the newspaper, his image was lowered down before me. Whenever I faced him, I used to recollect the contents of the news item, and I used to think ill about him. I used to think how this man, plaintiff, could contract second marriage during the subsistence of first marriage. I used to think that he might have illicit affairs prior to filing of the applications of divorce, and that is the reason why such materials have been placed, and that is why the reason why such materials have been
Published in the newspaper.
The Lord would see these 3 lines at page 41 at the bottom, which start with I used to think. My Lord, it rather negate the very evidence of PW1. I used to think
Hmm.
that he might had illicit affair prior to filing of the application for divorce, and that is the reason why such materials have been published in the newspaper. Rather, this corroborates the publications so made in the newspaper.
Hmm.
Those publications dated 3/12/2008 and 5/12/2008.
Hmm.
This PW2 happens to be the second witness to the plaintiff.
Hmm.
If my lord read between the line of PW2, this infers
Hmm.
then, as usual, at right from page 42, my lord, the witness, being a tutor witness, said same thing what the plaintiff has said in the plaint. I say I don't know the truth in the newspaper.
PW3.
PW2 only. I'm on
Acha.
page 42.
Acha.
Page 42. Then I drawn across the cross examination of the.
Hmm.
I say that I don't know the truth in the newspaper, but being an employee in the department, I know that gossips about the contents of the news item used to be made between the employees, and the majority is employees used to speak ill about the plaintiff after reading that. I say that news items has tarnished the image of plaintiff among his colleagues. I say that I could not give such respect to plaintiff as I used to give earlier before the publication of news item. I say that I found differences in the attitude and behavior of other employees in the department. Even they used to wish the plaintiff sell down. So this is the evidence of PW2. Now, cross-examination, to find at page 44. It's a handwritten cross-examination recorded by the presiding officer, Mr. Vinay Kumar Prasad. Not even.
Why it's so? It is dated 2012.
Yes, sir.
During those days.
No, it's been there. But this presiding officer had a practice of recording in his hand. For a not a fact, he used to use NAF. You are not to find it, it's there only. Robert C. Yes, at the 45 page 45, it's written, last paragraph, NAF. That I had used falsely as I was subordinate to him. A cross was put to the witness, PW2, that you being an interested witness, you have deposed on behalf of the plaintiff.
This should not be. When he was provided with a. Yes.
May I place it?
Yes.
Not page 44.
Yes.
The page 44 at the top is an that's an introductory paragraph. Cross examination, bro, can you see? Just below the signature of presiding
Yes.
officer.
Yes.
Yes. The publication. Yes, plaintiff is working in the same department. Plaintiff and I. Yes, the plaintiff and I is now is working in the same department. Got it, bro? Cross examination. Yes. No knowledge about the friendly relationship. Yes, they are. My opinion about the have no knowledge about the fact that plaintiff files any case before the Honorable High Court regarding against the municipal council at page 45. Not a fact that I used falsely as I was subordinate to him. Completed and discharged. This is the evidence of PW2. Then I can't type it also, Lord, because what is it? You can't type it.
There is only 2 pages, handwritten, only 2 pages.
It's written there, not to find at page 45 at the bottom, completed and discharged. Page 45, just above the signature of presiding officer, read over an excellent seal, to find in a single inverted comma, completed and discharged. Then comes to page 47, the evidence of PW3.
No, apart from these 2 pages, no other evidence is handwritten.
Handwritten, yes.
Everything is typed.
Everything is typed.
Yes.
Then comes page 47, he was one Mr. Mohammed Rafiq.
Another colleague.
Another colleague.
Okay.
Would see page 47. I have filed my examination sheet duly sworn by the academy, so that sheet part. cross-examination, my lord would find at page 47. My qualification is 9 pass. Khalil Rahman and M.S. Akbar are my brother, two elder brothers. A.S. Jinu, practicing advocate of this court, is the daughter of my brother M.S. Akbar. Shipati is the mother of A.S. Jinu. I do not know whether learned advocate Anjali Nag is contesting the case of mother of A.S. Jinu. I am a heavy vehicle driver of the water tanker. Not a fact that my statement in paragraph 3, 4, 5, 6, 7, 8, 8, my chief are totally false. Jackie Ahmed is the assistant engineer of PBMC. I know Jackie Ahmed and the plaintiff Ramchandra. I do not know whether there is any dispute in between them or not. I know the plaintiff at least since last 10 years. I know Jackie Ahmed when he was posted in our department. One Matthew Varghese also read the contents of newspaper dated 3/12/2008 and 5/12/2008. Matthew Varghese is worker under mechanical section. The plaintiff is assistant engineer in electrical section of municipal council. I do not know the ground of divorce filed by the plaintiff. Against the defendant, I also do not know the truth of that divorce. My wife Zubeda Begum was chairman of the Port Blair Municipal Council. I do not know whether any dispute has been disposed of by Honorable High Court or not. I also cannot say whether there is any dispute pending in between the plaintiff and defendant before the Honorable Supreme Court of India. I read out the fact displayed in the daily telegram on 3rd and 5th December 2008 that the divorce order passed by the district judge was set aside by the Honorable High Court. I do not know whether one Jaya is the PA to the plaintiff or not. I cannot remember whether it was in the publication newspaper that the order passed by the High Court has been challenged by the plaintiff before Supreme Court. What respect I had for the plaintiff prior to reading the newspaper as stated, I do not pay such respect to him at present. My opinion is that the government officer should not marry for second time during existence of first marital status. I also thought that the plaintiff is a character. I also thought that the plaintiff is a characterless. I cannot say that the opinion of my colleague, namely Matthew Varghese, who also read the newspaper of the 11 days, page 49. Not a fact that there was no publication in the newspaper had stated that Ramchandra is going to marry for the second time during the subsistence of first marriage. It is a fact that there is no name of lady in newspaper whom Ramchandra was going to marry. Not a fact that as qualification is up to 9th and I could not read out the newspaper. Not a fact that as my qualification is up to 9th, I could not read out the newspaper. My opinion as well as the opinion of Matthew, which I have stated above, form after reading the newspaper dated 3/12/2008 and 5/12/2000. I have read the newspaper dated 3/12/2008 on that day, and by the same way, the newspaper dated 5/12/2008 on 5/12/2008. My duty hour is 6 a.m. to 1 p.m. regularly. My attendance register is maintained in mechanical section. The assistant engineer maintains the same. The secretary of PDMC may send indent for newspaper. The newspaper dated 3/12/2008 and 5/12/2008 were kept at place where the attendance register was. Not a fact that I am proposing falsely to support the plaintiff as he is working in municipal council. So these are the evidence of plaintiff's argument. Then I adduce in evidence in rebuttal.
Yes, Mr. Chairman.
Cross-examination was done at page 47. Because chief of DW1 is in tune with the defense which I raised in the written statement. You will not see the cross-examination. Nothing could be
Cross-examination of
DW1 at page 57. That's
DW
different. Page 57 of
DW1.
DW1. Because DW1 executed the order of the Honorable High Court, which was marked as Exhibit A.
DW1.
DW1, not at the top. Then I'm waiting further cross-examination. Exhibit 3 and 4 are shown to the witness. These are publication made by me. 25 divorce case and that was decreed in his favor, but I do not know the date of passing of the decree. I preferred appeal before the Honorable High Court. I had preferred appeal in 2008 challenging the level of divorce, and that was disposed of in my favor. I got married with 20.22/1994. My child born on 24th January 1990. It is true that in my written statement, I alleged that my husband had illicit relationship with one lady employed in Portland Municipal Council. I did not file any suit for restitution of conjugal rights. I did not prove the allegation of illicit relationship of my husband. Lady is now aged about 50 years old. My son is residing with my husband. I do not know the name of the lady with whom my husband was going to marry. I took endeavor to correct particulars of that lady, but could not succeed, even though I went paper publication. It is not a fact that my paper publication was made me only to detain my husband. It is a fact that my husband has preferred second appeal before the Honorable Supreme Court, challenging the order passed by the Honorable High Court in our divorce suit, which is sub judice. It is a fact that I did not mention the name of persons in my written statement from whom I have informed that my husband was going to marry, nor even I mentioned in my examination. Not a fact that I did not derive any knowledge that my husband was going to marry and the publication was published to defend my husband. My husband did not marry for second time as yet. Since after filing divorce suit till date, I took many attempts to make conversation with my husband over phone, but he did not come. My husband was not at all affected due to the paper publication. I do not know what is his friends and colleagues told of him about this paper publication. I do not know as to whether the friends of my husband, his staffs and senior asked me, my husband, depending on the paper's publication as to whether he is going to marry for the second time or not. Not a fact that I told my son that his father is going to marry for the second time. Not a fact that the plaintiff has detained and his reputation has spoiled due to the paper publication. I know that until and unless the decree of divorce is effected, none of the spouse acquires right for the second marriage. And if he does, it is punishable. My husband is an assistant engineer in Portland Municipal Council. I have published the publication in Daily Telegram, but I know whether it is widely circulated or not. I have read the same after publication. Not a fact that I am liable to pay compensation to my plaintiff as he has been detained and his prestige has been lowered down in the area of public. Not a fact that the paper publication was false and malicious. Not a fact that the justification to publish the publication in newspaper which I made out in the written statement as well as in my memo available that completely false. But testimony could not be shaken in any way. But then I used my second witness as lead up to one Mr. Nageshwar Rao. And my lord would see.
Who is this person?
He not happens to be the person who is working under the Portland Municipal Council. He has in paragraph 1 has deposed about acquisition of his knowledge about Ramchandra marrying for the second time. He deposed at page 59, paragraph 1. I know Ramchandra, who is working as assistant engineer electric division under the Portland Municipal Council. It has come to my knowledge in the last month of year 2008 that the said Ramchandra was trying to get married another lady during the subsistence of marriage between himself and Ananta. Such fact was informed to me by my some friends. I have also come to know that Ananta succeeded in an appeal which she filed, challenging a divorce judgment and will be granted by the district judge in favor of Ramchandra, and the High Court has reversed such finding. This witness has deposed on behalf of the defendant. I will show the cross examination at page 62 of DWP. Page 62. Cross examination. I know the defendant for the last 20 to 25 years as she is employed under my department. I never went to the house of plaintiff and defendant when they were residing together. I did not mention in my examination sheet the name of person from whom I had the plaintiff is going to marry another lady. I also did not mention the name of that lady to whom the plaintiff allegedly going to marry. I have no knowledge as to whether the Ananta, the defendant of the suit, preferred any appeal against the plaintiff and won the matter, or the said matter is now subjudized before the Honorable Supreme Court of India now. So I have mentioned in my examination that in the month of December 2008, I came to know that the plaintiff was going to marry, but then my knowledge I acquired with facts in the month of January 2009. I did not tell the matter to the defendant that I came to learn that the plaintiff was going to marry. Not a fact that I am reposing forward today as per the instructions.
I did not tell the matter to the defendant that I came to learn that plaintiff was going to marry.
So then comes lordship the third witness as a defendant. It starts at page 64. Page 64. I know Ramchandra, who is working as assistant engineer, electrical division under the Portland Municipal Council. It has come to my knowledge in the last month of year 2000 that he said Ramchandra was trying to get married with another lady during the subsistence of marriage between himself and Nanda. Such fact was informed to me by some of my friends. I have also come to know.
PW2 is the employee of Port Blair Municipal Council.
DW2.
DW2.
No, he was their employee under the APWB. It's Nageshwar Rao. He was employed under the APWB. Lord would see at page 62. Page 62. His designation. My occupation is
Junior engineer.
APWB. It's a different department. Andaman Public Works Department.
Achha.
DW3. Any further detail as regards DW2?
Achha, junior engineer, Andaman Public Works
Department.
Separate department.
Separate entity.
And DW3 is.
It's a private worker.
The private worker means?
Lord, see at page 67.
67.
My occupation is a private work. She is not employed in any department.
Achha. He is not employed in any department.
No, she is nowhere connected. She is nowhere connected.
Yes.
In any department.
Yes.
She has also deposed lordship that she has heard this fact about marriage being like to be conducted by this Ramchandra. This is her lady. When the Lord would see at page 67, Lord would see the page 67, save and accept as regard our identity. Because challenge in at page 67 has been made by plaintiff to her identity only. But what she has said in chief, there is no cross-examination, nothing at page 67. Lord would say, I am not summoned witness, I have not produced any document to establish that I am Saraswati Roy. I have no relationship with defendant, but she is known to me. My husband has no relationship with the husband. My husband is Parishiti Chatterjee, not a fact that I am not Saraswati, nor that I am reposing falsely today as per the instruction of the family. There is no even suggestion given to this witness as regards the contents made in paragraph 1 of the chief about acquisition of knowledge by her about Ramchandra trying to marry for the second time during the subsistence.
There is no cross-examination on that regard.
On that, not even a suggestion has been given to this witness by the plaintiff. Her identity was disputed that you are not this lady. Lord knows the chief was filed invoking order 18 rule 4 of CPC. So far as evidence of DW3 is concerned, the satisfaction as regard identity would be made before the oath commissioner. Lord would see page 65 of that's the certificate part of the DW3.
Yes.
Lord, page 64 is the chief of DW3, and Lord turns to page 65. Lord would see the certificate is because under order 18 rule for a certificate is appended at the book. Lord would see commissioner, oath commissioner has upon satisfaction as regard our identity affirmed it. When that is done, the question so put to this witness about our identity is of no consequences, I would say. And moreover, as I've said just now, nothing with regard to the paragraph 1 of the chief.
So 3 PWs and 3 DWs.
Yes. But the written statement which my client have used in the divorce proceeding were exhibited by the plaintiff in this damages suit, which is at page 70. There I have given the name of that lady, Manju. I'll show that. Page 70 is the written statement used in the divorce proceeding by my client. I'll show that. And this document was been brought in by the plaintiff in the damages suit. I'll just show that. Yes. Yes. Page 80, not page 80, running page 11 of the written statement, second paragraph.
Page
80 of the paper book. It's a running page of written statement 11. Oh, sorry, internal page. Running page is 80, internal page is 11.
Yes.
Second paragraph. It is during January 2005, February 2005 that opposite party learned that the petitioner in that proceeding was a husband. Her husband for quite some time has having an extramarital affair with a lady named Srimati Devi working under him. When opposite party confronted him with the information of this illegitimate relationship, the petitioner created a big scene, shouted and abused the opposite party, and told her that the information of his illegitimate affair with any working under him is true, and he shall do whatever he feels. The petitioner on the same day collected her son from the school in the evening and forcibly has kept the child with him. So the name has been disclosed. This written statement is a documentary evidence so far as the damage suit is concerned. But above all, my lord, I'll draw my lords to the judgment of the Honorable High Court. I will draw my lords to the order of the Honorable High Court while reversing the decree of divorce. There, my lords, the High Court have come to a conclusion that extramarital affairs cannot be open one. It's always concealed. And the Honorable Court has drawn an adverse inference, my lord, that based on the material on record, it can be presumed that the husband was having an extramarital with that lady, Manju, whose name I have disclosed in the written statement. I'll show that order also. On that count only, my lordship, both the judges formed two different opinions, but have come to an ultimate conclusion that the decree of divorce granted by the district judge needs to be reversed. The findings were two different.
One second. One second.
The two judges. May I name the judges?
No.
Two judges, while deciding my appeal against the decree of divorce, have ultimately reversed the decree of divorce. But two separate opinions were formed to come to such conclusion. In that judgment, I'll show that the court has accepted the contention of the wife that in fact the husband had an extramarital affair, because extramarital affairs cannot be an open one. It is always concealed one. The attending circumstance needs to be seen. The court has inferred such, drawn such inference while reversing the decree of divorce. But the paper publications were made after the High Court passed the order.
After the setting aside of the decree.
Yes.
3/12/2008 and
5/12.
5/12/2008. Judgment of the
High Court is dated
First appeal.
24/11/2008.
uh,
24/11/2000.
first appeal, judgment dated 24/11/2008.
2008. No, may I take cross because this judgment was an exhibited document from my side before the trial court in the suit for damages. But page 115.
Yes.
But it's in FA number 003 of 2008,
Hmm.
Srimaniti Ananta versus Ramchandar.
Hmm.
The names of the counsel given, judgment on 24/11/2008, Ashiv Kumar Banerjee.
Hmm.
I'm just placing it now.
Hmm.
I have read the well-versed judgment written by my esteemed brother. I am in full agreement with the conclusion my lord has arrived at. To supplement, I however wish to add few lines in this regard. His lordship referred to the conciliation proceeding which we had in our chamber. They intentionally had held the.
This one should be the other portion.
The
Where is
first
the-
portion is of His Lordship Honorable Justice Himanta Datta, 120. 120.
Why this one? 1 minute.
Or 120. This could have come later on.
Hmm.
Yes. Maybe for the reason Lordship, because it does not lie in my mouth to say, because
This is the judgment.
yes,
Okay.
to see page 120. I'll read from page 120. The decision arrived at by the Honorable Justice Himanta Datta.
Entire is 22 pages
Yes.
till 136.
Yes.
Yes, that is possible.
I'll start with page 120.
No.
From first place. I have heard the well-versed judgment written by my esteemed brother. I am in full agreement with the conclusion my lord has arrived at. To supplement, I however wish to add few lines in this regard. His lordship referred to the conciliation proceeding we had in our chamber. We intentionally held that the conciliation proceeding in presence of minor child who was accompanying his father. From the demeanor of the child, I cannot resist my temptation to observe that my lord is correct to the extent that child is under the influence of his father. The child was about 6 to 7 years when he was separated from his mother, according to respondent. He deposed before the learned district judge when he was 11 years. Now he is 12 years. The factum of influence, in my view, is not an unnatural because of his tender age and long dissociation with mother. As has been observed by my lord, the learned district judge placed heavy reliance on the evidence of minor child while coming to the conclusion that the appellant was responsible for mental cruelty being inflicted on her husband. My lord has analyzed the evidence in detail. I need not repeat the same. My endeavor is to find out whether the evidence available on record could support the allegation of mental cruelty. According to American jurisprudence, the term mental cruelty means a course of unprovoked conduct towards one's spouse which causes embarrassment, humiliation, anguish, so as to render the spouse life miserable and unendurable. The apex court in the case of A. Jayachandra versus Anil Kaur reported in 2005 cases observed to constitute cruelty, the conduct of complaint of should be grave and weighty so as to come to a conclusion that the petitioner's spouse cannot be reasonably expected to live with the other spouse. It must be something more serious than ordinary wear and tears of married life. The conduct taking into consideration the circumstance and the background has to be examined to reach the conclusion whether the conduct complained of amounts to cruelty in the matrimonial law. Conduct has to be considered as noted above. In the background of several factors, such as social status of parties, their education, physical and mental condition, customs and tradition, it is difficult to lay down a precise definition or to give exhaustive description of circumstance which would constitute cruelty. It must be of type as to satisfy the conscience of the court that the relationship between the parties had deteriorated to such an extent due to the conduct of the other spouse that it would be impossible for them to live together without mental agony, torture, or distress to entitle the complaining spouse to secure divorce. In this backdrop, I am of the view that there cannot be any straitjacket formula wherein available evidence be put to test to have results whether it would amount to mental plurality entitling the complaining spouse to get decree of divorce. In the case in hand, we find that according to the husband and the child, the lady was ill-tempered, in habit of quarreling with landlords, abusing husband, and the son by calling them Dhobi and Dhobi ko aulad respectively, cooking food for herself only, insisting the husband to live separately, leaving his parents. If we consider these evidence on face, we would find that the lady was selfish in nature, wanted to have a nuclear family. She was also ill-tempered. Do we find any several women in our society having all these shortcomings? If we grant divorce to their respective husbands, our society would break down immediately. Marital bond, in my view, is not a glass pane or a fragile object which could be broken considering the wear and tear of the marital life. It is such that a man and a woman, after considering each and every aspect of life, they could be in a position to live jointly forever, entering a marital bond, forgetting their respective past. This tradition is continuing for decades after decades, ages after ages. A person might be ill-tempered by nature of or because of physical ailment. Once both of them enter into marital bond, it is their solemn duty to maintain the same unless it is irretrievably that which should be broken. If one is ill-tempered, it is a duty of other to keep him or her cool. To maintain a relationship, both of them would have been sacrificed by sacrificing their personal wish or choice and by adopting other wish or choice of his or own. This is how a marital bond is strengthened. If the court of law encourages breaking down of relationship on trivial issues, sooner or later our society would face a disastrous situation. In the case in hand, according to the respondent, the husband left her matrimonial home 5 years ago in 2003. There might be repentance on her side. She might have amended herself. We asked the respondent to go for conciliation by spending weekend at a suitable place in a congenial atmosphere. The appellant agreed. However, the respondent did not. He kept mum before us. However, did not adhere to our request. Both the parties are educated. They are working under the administration. There is no allegation of physical violence from either side. We fail to appreciate as to what damages.
The husband was in the Port Blair Municipal Council. The wife,
APW.
APW.
Yes. Andaman Public Work Department. Andaman Public Work Department. The 119 last 3 lines. There is no allegation of physical violence from either side. We fail to appreciate as to what damages could have been caused to the respondent, husband, while trying for a conciliation in deference to the desire of the court. This would only show that the respondent is bent upon to strengthen the order of divorce, as he is not interested in maintaining the marital bond. If he uphold the degree of divorce, it would be a premium to his ill will and would carry a wrong signal to society at large. I am therefore fully agreeing with my lord when my lord allows the appeal by setting aside the decree of divorce. Now the finding arrived by this law. The respondent husband instituted a suit in the court of district judge Andaman and Nicobar Island against the appellant wife. Section 13 of the Marriage Act praying for the decree of divorce to dissolve their marriage. The suit was decreed. Pleading agreed thereby the wife is in appeal before this. This court heard the spouse in chamber for exploring whether any reconciliation is possible or not. While the appellant was agreeable to return forgetting past incident, the respondent did not agree. The court then requested the respondent to have conversation with the appellant outside the court during the weekend so that if differences are sorted out, the marital bond could be saved. While before the court, The respondent agrees. It has been since been informed by Mr. Jaipal, learned counsel for the appellant, that the respondent did not contact her. Thus, the endeavor of the court to bring about the reconciliation failed, leaving no other option but to decide the appeal on merit. Mr. Jaipal invited the attention of the court to the pleadings and the evidence on record and contended that the learned trial court failed to appreciate the same in the proper perspective and rendered a judgment which cannot be sustained in law. Over reliance placed on the evidence of PW2 being the child of the parties was criticized on the ground that the child's competence to depose had not been duly verified, and therefore the same ought not to have been acted upon. According to him, the child had been tutored. Further, he contended that the incident complained of in the claim were not such so as to warrant a decree of divorce. On the finding that the appellant had treated the respondent with cruelty, he invited the court attention to the paragraph 101 of the Apex Court decision reported in 2004 SEC 511 Samar Ghosh versus Jaya Ghosh, and contended that the cruelty cannot be said to have been established. So far as the ground of discussion is concerned, he submitted that the learned trial court erred in law in not duly considering the evidence of defense witnesses and rejecting the same without cogent evidence. He argued court to set aside the impugned judgment and decree. Per contra, Mrs. Nag, learned counsel appearing for the respondent, contended that the impugned judgment did not suffer from any legal infirmity warranting interference. He stressed that in the present case, the child was an independent, disinterested witness who deposed from the core of his heart, and the learned trial court was justified in placing on his land. She also placed his reliance on the decision of Samar Ghosh Supra to purchase her contention that the relationship between his spouse was ensnanced and their marriage having broken down irretrievably. The decree of divorce granted by the learned trial court ought not to have been upset. She prayed for dismissal of the. Before this court proceed to examine the contentious issue, it would be worthwhile to take note of paragraph 10 of decision in Samar Ghosh, but these guidelines have been reduced. I'm just skipping this. I'll take cross to straight away to page 124. These are the guidelines
laid down by the Apex Court.
which act amounts to quality.
It is not exhaustive, but
It's not exhaustive, absolutely not. It's not exhaustive. Page 124. Keeping in mind the instance extracted supra, the respective claims and the judgments under appeal may now be considered. The respondent founded his claim on the ground that the mental cruelty was perpetrated by the appellant on him and that she had deserted him and the minor child born in their wedlock for more than 2 years. The respondent internally alleged in the petition that immediately after the marriage had been solemnized on 2nd March 1994, the appellant insisted for a nuclear family, showing dislike towards the joint family of the respondent, and that she frequently shouted and accused him in front of members of the joint family. That since her demand for separate house was not accepted, she lodged a complaint under section 498 of Indian Penal Code, which was later on withdrawn by her, realizing that it was she who was at fault. That she had lodged a complaint before a woman's cell, and on being summoned, she had stated the entire facts, whereupon no further action was initiated. That because of constant torturing which was inflicted on the members of joint family by her, she had to arrange a separate accommodation that she constantly abused him with calling Dhobi, and minor son was similarly abused and was called as Dhobi Kaula. That because of her rude behavior with respective landlords and neighbors, she had to shift residence on a number of occasions, that she refused to perform any household works and did not take proper care of minor child, for which she had to bring foods for child from outside. That ultimately in the month of March 2003, she left her matrimonial house and went to her parent house and did not return since then. And that she had never behaved properly with her husband, nor had she been a good mother of child. It was further alleged that the conduct and the temper of the appellant created reasonable apprehension in the mind of respondent that it would unsafe for him to live with her in future, since she was frequently causing mental torture and the harassment to him. Since the appellant had caused a high degree of mental cruelty on the respondent and had even deserted him and living separately for more than 3 years, a decree of divorce was prayed for under 13(1)(1)(1)(a) and 13(1)(1)(b) of the Act, dissolving the marriage solemnized between the parties on 2nd March 2004. The suit was contested by the appellant by filing written statement, wherein she denied and disputed the material allegation contained in the claim. She asserted that she had never behaved improperly, disgracefully or irresponsibly as wrong alleged. It was alleged by her that since her father was working as chowkidar, the family members of the respondents were ill disposed towards her, and that even grumbled for non-payment of dowry by her family for the respondent was ingenious. She also alleged that she withdrew the complaint in section 498 of the court considering her future and on being persuaded by her parents, she asserted that she took good care of her child and question of inflicting torture either on the respondent or on the child did not at all arise. She had also leveled a very grave allegations that the respondent was involved in an extramarital affair with the lady who was working in the inn. Whenever she confronted him in this aspect, he raised his voice and shouted and abused her and cheated, created big scenes, and that he made up his mind to live with that lady once marriage between him and her dissolved. She accordingly prayed that the suit should be dismissed. In support of the plaintiff case, the respondent examined himself, the minor child, and the servant, whereas apart from appellant who deposed in defense, 4 other defense witnesses adduced for her. The suit went to trial upon framing following issues. The issues were reproduced in lawsuit. Then, although no issue was framed on the point of plurality of wife towards the husband, the learned trial court considered issues number 3, 4, and 5
Yes.
No, we are at page number 129.
120.
Start with page number 120 second paragraph.
126.
No, 126 we have not done. 126 we read it.
We have gone
Tamako
through.
Jagos guidelines will.
Yes,
stick it.
yes, the Samarkand Jayagos has been stated. Samarkand Jayagos. Acha. So 129.
129 second paragraph.
Hmm.
The next allegation. May I start?
Yes.
The next allegation of the child which found favor for the trial court is that appellant used to cook food for her own, but was reluctant to cook for the respondent, and the child for which food had to be brought by the respondent from outside, thus amounting to mental cruelty. It appears from paragraph 19 of the plaint that no allegation was leveled by the respondent that the appellant only cooked for herself without caring for the child and him. On the contrary, the allegation was to the effect that the appellant was reluctant to do any household works. In paragraph 17 of the affidavit evidence in chief, the respondent did not allege that the appellant used to cook food for her only. Her reluctance to do any household work, even if accepted, without anything more on the face of the fact that she was working lady would not justify the conclusion that the same amount of cruelty behavior warranting a decree of divorce. The evidence of child in this respect is therefore unworthy of credence, and the paragraph 29 of the decision in Samarkand Supra would have no application here. The learned trial court also appears to have been impressed by the evidence of the child when he objected to the appellant wanting to live with him and his father. The child may have been deprived of care and affection, which a non-working mother would have given to her child in normal circumstances. Being a working mother, she may not have enough time to spare for her child, resulting in a feeling of not being cared for and even hatred towards her. Any impression of child emanating from a sense of hatred towards his mother is due to incompatibility, which is an attitude problem and could have been solved. Being a child of tender years, he is yet to understand the significance of ma. The liking which a child may have for his father may not be comparable with that of appellants because of his incompatibility. But this again by itself would not tilt the balance in favor of respondent, since in a proceeding for divorce, it is the nature of cruelty inflicted on the spouse that is relevant and the material, and the respondent failed in establishing that the present case covered by the instance enumerated in clause 1, 2 and 10 of para 101 of decision in Samarkand. Reliance placed by the learned trial court on the evidence of child appears to be misplaced. The child was born in January 1996. According to plain case, the appellant deserted the husband in 2003. The child was then only about 7 years old. His deposition was recorded in September 2007. By the time he was 11 years old, a child would not ordinarily lie. But being of tender age, the likelihood of being tutored cannot be ruled out, especially when he had been residing with his father since the alleged separation in 2003. Quite apart, it is unlikely that a child of 11 years would remember every minute details of his early life, that he would not be inclined to have his mother stay with him or his father. Whether the marriage had irretrievably broken down beyond repair is a question which has to be answered having regard to the facts of particular case. But the evidence on record would certainly not justify a decree of divorce, particularly when the facts reveal situation covered by clause 9 of para 101 of the decision in Samarkand Supra. The further conclusion drawn by the learned trial court that the institution of a criminal case under section 498A of Indian Penal Code by wife and its withdrawal had an adverse impact upon the mind of husband has also failed to impress us on the face of the defense version that the parties had arrived at a compromise which was not disturbed in cross-examination, and not that the criminal case was meritless. Also, the evidence of the mother of the wife to the extent referred to impugn judgment cannot be said to be adequate proof of allegation that the complaint was based on false accusation. The true it is that filing of criminal complaint containing false and baseless allegation may disturb the conjugal life of a couple and may amount to creating such anguish that the same adversely affects the mental health of husband and thereby may, in an appropriate case, be a ground for seeking divorce. However, The very fact that the respondent continued to live with appellant even after withdrawal of criminal complaint is sufficient to hold that such filing of complaint may not have an aberration on the part of appellant which stood condoned by the respondent. Although the date of filing of criminal complaint by the appellant under section 498 of Indian Penal Code has not been mentioned in the plain, from the sequence of narration of events, even therein, it appears to have been filed prior to the birth of child. The passage of time after such withdrawal till the alleged separation of 2003, more or less 7 years, is a relevant factor which appears to have been overlooked by the learned trial court. The finding that the respondent did not condone such act of the appellant is based on erroneous appreciation of fact. The final ground which the learned trial court based its judgment allowing the petition for divorce of ground is that the appellant had utterly failed to prove, here is the catch, my lord, had utterly failed to prove the respondent had been involved in an extramarital affairs, and this allegation had an adverse impact on the conjugal life. It considered the status of respondent and the said lady, a daily rated mazdoor, and a return finding that the allegation was not founded on any reasonable acceptance evidence, and thus the allegation was unfounded. This court is unable to be ad idem on this court. The appellant had mentioned the name of lady with whom the respondent allegedly was having an affairs. Though the respondent admitted that the lady was working with him, the allegation that he was having an affair with her was denied. If one is involved in an extramarital affair, which is a social crime, it would hardly be an open affair, and in most cases be in a clandestine one. It would be difficult for a wife to prove such allegation by adducing witnesses. Mere failure of wife in such a case to prove her allegation ought not to have weighed in the mind of the trial court in declaring the suit and thereby putting an end to a long-standing relationship of almost 14 years. For the reason aforesaid and on analysis and evaluation of entire order, we are unable to agree with the learned trial court that the ground of mental cruelty has been duly established by the respondent. Turning now to the ground of desertion, we find that the learned trial court did not agree with the submission advanced on behalf of the appellant that DW 2, 3, and 4 had seen the spouse together even during 2005 and that their version stood undisturbed during cross-examination. It proceeded to record that I failed to agree with the submission because of some way or other the contention of those witnesses were controverted in cross-examination. On what score the evidence of DW 2, 3, and 4 was not found reliable, however, has not been indicated with any degree of clarity in the impugned judgment. Having perused the evidence of the said witnesses, this court does not find the evidence of the said witness unworthy of credence. The learned trial court therefore committed an error in law in appreciating the evidence of DW 2, 3, and 4 in proper perspective, which has the effect of vitiating the judgment under appeal. The evidence on which the ground of desertion has been found to be proved is that of child. The statement made by child that the appellant voluntarily left his father's house in the year 2003, although has weighed in the mind of the learned trial court, however, has not inspired the confidence of this court. A child of 7 years not so mentally developed so as to understand whether leaving the house by his mother was voluntarily or not, particularly when he was not present in the house, when she left the house, which he noticed after returning from school. It is also impossible for such a child to acquire any knowledge at the age of 7 years. That is his experience that his father was affectionate to his mother. Although the learned trial court has been impressed by the evidence of child as one coming from the heart and ruled out that he was not been tutored, this court is unable to share the same view. Evidence of child witness has to be scrutinized carefully. A child witness is prone to be influenced by his elders, and in a case of the present nature where the appellant being a working lady had to detach herself from the family for official reason, it is quite natural that being in the company of father, he may develop a predisposition of giving a version favorable to him. This court is of the considered view that the learned trial court placed too much reliance on the evidence of child, although same did not deserve. A marital bond between a couple is a sacred one, which ought to be severed only on clear establishment of cruelty of such a nature that life of one of the spouse becomes miserable and not worth living together. The conduct of the appellant that had complained of appears to be not so grave and weighty that it can be treated more serious than ordinarily wear and tear of married life. The learned trial court was not justified in declaring the suit by dissolving the marriage between the appellant and the respondent on the state of the evidence adduced before it. The appeal therefore succeeds and is allowed. The impugned judgment decree stands set aside. The suit is dismissed. But the finding arrived at by the Honorable Court, more particularly which I have read just now, as regards the proving of my husband having extramarital, my Lord would see the High Court has clearly held it can't be proved by wife. I have spelt out the name of the lady with whom my husband was having extramarital affair. This has been considered by the court, and this judgment has been exhibited A. But now what rests with the matter in appeal is, my Lord, the two publications. And now I'll draw loss to the trial court judgment, which starts at page 138, dismissing the suit for damages. I'll not take away straight to from page 148, where the decision with reasons has been given. Page 148 of the paper book. Issue number 1 and 3, these issues are taken up together for convenience of consideration taking decision. The learned counsel appearing on behalf of the defendant relied upon the referred decision and Article 75 of Limitation Act, argued that the suit is not maintainable and it is barred by law of limitation. According to him, in libel action, the defamatory word must be set out in the plaint. Accordingly, according to him, the alleged defamatory statement has not been set out in the plaint. He further submits that in view of Article 75 of Limitation Act, the suit is barred by limitation. On the contrary, the learned counsel plaintiff argued that the actual wordings which are set out in the paper publication marked as Exhibit 3 and 4 are well set out in the plaint. More so, in view of Article 75 of Limitation Act, the limitation for filing the suit for defamation is 1 year. In fact, Article 75 clearly speaks that the limitation in 1 year for filing the suit from the date of cause of action. In the instant suit, as prayer for plaintiff, the cause of action arose on the day of publication of notice in the Daily Telegram on 3rd December and 5th December 2008, respectively. On perusal of Exhibit 3 and 4, which are the notices published in the Daily Telegram, it appears that the said notices were published on 3rd and 5th December 2008, and the instant suit was filed on 1/1/2009. That is well within the time, and on perusal of the said publication, it appears that there is sentence. It has now been learned from libel source by Srimati Anantara, wife of Sri Ramchandra, that her husband is trying to marry another girl is in contrary to law, by which both my clients and the said Ramchandra are governed. This averment of notice published in the Daily Telegram on 3rd and 5th December 2008 has been set out in the plaint. Therefore, in the considered view of this court, the submission advanced on the side of defendant is not acceptable, and it is held that the suit is very much maintainable and it was presented within stipulated time limit. Thus, these two issues are decided in favor of plaintiff. Issue number 2. This issue is taken up for consideration and taking decision. Mr. KMB Jaipal, learned counsel for the defendant, further argued that there is no cause of action at all. Mere publication of notice in the Daily Telegram did not cause harm to the plaintiff. It is a general notice to the public and not to the plaintiff. On the contrary, Srimati Anjali Nag, learned counsel for the plaintiff, argued that the notices displayed in the Daily Telegram on 3rd and 5th December 2008 are defamatory to the plaintiff, who is by the post an assistant engineer in Port Blair Municipal Council. After hearing both the sides and on perusal of the Daily Telegram published on 3rd and 5th December 2008, this court has no hesitation to hold that there is cause of action to file the instant suit. Accordingly, this issue is also decided in favor of plaintiff. Issue number 4 at page 151. This issue is also taken up alone for consideration and taking decision. Neither sides press this issue, and on perusal of evidence on record as well as the facts and circumstances of the suit, this court does not find that the suit is barred by a principal estoppel waiver acquiescence. Thus, this issue is disposed of in favor of 5. Issue number 5. This issue is also taken up alone for convenience of consideration taking decision. The learned counsel for the defendant argued that the suit is suffers from misjoinder of parties. According to him, Sri Ashim Poddar, editor Daily Telegram, Government Press, has been implicated as defendant number 2 in the suit. In fact, the notice which was published in the Daily Telegram is not at all the news, but an advertisement of notice on payment of basis. There is a difference between notice and news. He further submits that the editor has nothing to censor in the notice, but this notice for general public published by the individual concerned on payment basis and not by press suo motu as a news. Contrary contention was taken by rival side, arguing that Before publishing any newspaper, the editor ought to have had very cautious regarding the genuinity of the subject matter being published. In the instant suit, the editor did not take any such attempt to collect correct information as to whether Ramchandra was trying to marry another girl or not, but this publication has given great effect upon the colleagues and acquaintance of the plaintiff, which is not only false but also cook and bull story. In fact, defendant number two, though has filed written statement but did not adduce evidence. In the written statement of defendant number two, it has been categorically mentioned that since one advocate, namely Sri KMB Jaipal, submitted a draft copy of notice for publication, the defendant number two did not think it to censor because it relates to court matter. On good faith, the notice was published without any malice. Now, this court takes an endeavor to differentiate the meaning of notice and news. Notice. Notice means, as per Transfer of Property Act 1882, Section 3, a person is said to have notice of a fact when he actually knows that fact, or when, but for willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have no need. Notice is not the same as knowledge. Notice is a word which involves that knowledge may be imparted by notice, but notice and knowledge are not the same thing. Although loosely one sometimes talk as if to act with notice and to act with knowledge were indeed the same. As per section 229 of Indian Contract Act and as per section 3 of Indian Trust Act 1882, notice means a person is said to have notice of fact either when he actually knows that fact, or when, but for the willful and abstention from inquiry or gross negligence, he would have known it, or when information of the facts is given to or abstained by his agent under circumstances. News, it has been held in AIR 1988, Supreme Court 1325 in the case of AR Karmachari Sangha versus AR Limited, and in AR 1983 Bombay 201 in AR Limited Nagpur versus State, that the news means tiding, new information of recent event, new occurrence as a subject matter of report or talk. Therefore, we get a clear distinction between notice and news. In the instant suit, the publication made on 3rd and 5th December 2008 in the Daily Telegram Port Blair, and which has been marked as Exhibit 3 and 4, do in no way come within the meaning of news, but it's a clear case of notice. More so, publication was under the caption notice. Though the plaintiff has impleaded defendant number two being the editor of Daily Telegram, but it suffers from misjoinder of parties. Accordingly, this issue is decided against the plaintiff. Additional issue number. The case of the plaintiff is that he has been defamed by the defendants by publication of notice in which defamatory statements have been used against him. Learned counsel for the plaintiff argued that defendant in Exhibit 3 and 4 published the notice mentioning it has now been learned from reliable sources by Srimati Ananta, wife of Sri Ramchandra, that her husband Ramchandra is trying to marry another girl. But neither the defendant nor any witness were able to state the name of that girl, nor even succeeded in proving that allegation. It is a defamatory to the plaintiff. Now this court is to understand what is defamation. As per section 499 of Indian Penal Code 1986, defamation is whosoever by words either spoken or intended to be read, or by sign or visible representation makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is said to defame that person. As per Husbury Law of England, 4th edition, volume 28, para 10, page 7, defamation means a defamatory statement is a statement which tend to lower a person in the estimation of right thinking members of the society generally, or to cause him to shunned or avoided, or to expose him to hatred, contempt, or ridicule, or to convey any imputation on him despairing or injurious to him in his office, professional calling, trade or business. It was held in Sim versus Stretch 1933 to ALL ER 1237. The test of defamation is, would word tend to lower the plaintiff in the estimation of right thinking member of the society generally. Therefore, it is seen by this court as to whether the plaintiff has been lowered in the estimation of right thinking members of the society or not. Learned counsel for the plaintiff during course of her argument referred decision held in 1969 SCR to 1962 and argued that the husband and wife are not one in the eye of law. They are separate entity. The character of the plaintiff has become questionable to his office colleagues and other people who know him after going through the publication. In support of a contention, learned counsel for the plaintiff attracted the notice of the evidence adduced by PW2 and PW3, who deposed before this court that they had earlier very high thinking about the plaintiff. After going through the contents of the newspaper, the image of the plaintiff has been lowered down before those PWs. They always used to ask the plaintiff whom the plaintiff is going to marry and how the plaintiff can marry for the second time during the substitution of marriage. She further submitted that the plaintiff in her deposition has clearly stated that in the mind of his office colleagues, friends, even his son had grown a bad images against the plaintiff, and plaintiff does not get proper respect from his office colleagues and friends, which he used to get earlier. The cited decision is with regard to section 122 of Evidence Act 1972, whether in the matter concerning communication during the marriage, and that no person who is or has been married shall be compelled to disclose any communication made him during marriage by any person to whom he is or has married, nor shall permitted to disclose any such communication unless the person who made it or his representative in the interest consents expect in suit between married person or proceeding in which one married person is prosecuted for any crime committed against the other. The facts and the circumstances of the referred decision is not helping the case of plaintiff in the periphery of the present circumstance of the suit. It is a fact that defendant published the notice making statement. It has now been learned from reliable source by Srimati Ananta, wife of Sri Ramchandra, that her husband is trying to marry another girl. In section 499 of Indian Penal Code, there are some general exceptions. Those exceptions are made in subsection 26 of section 4, subsection 26 of section 499 of Indian Penal Code as follows. Imputation of truth which public good requires to be made published, public conduct of public servant, conduct of any person touching any public question, publication of reports of proceeding of court, merits of case decided in court or conduct of witness and other concern, merits of public performance, censure, passed in good faith by a person having lawful authority over another, acquisition preferred in good faith to an unauthorized person, imputation made in good faith by a person for protection of his or other interest, caution intended for the good of to the person to whom it is conveyed for the public good. As per clause 9 of subsection 26 of the Act, the wife, here in this case Ananta, the defendant being the wife, the plaintiff must seek protection of her interest while their conjugal life bears a checkered history. Admittedly, they got married and they have a son, but the plaintiff filed a divorce suit and got decree, and subsequently in the first appeal before the Honorable Court, the same was set aside, and the second appeal has been preferred by the husband-wife. The plaintiff in the divorce suit leveled many allegations against her wife, and in the first appeal, the wife defendant had also mentioned the name of lady with whom the plaintiff has illicit relations, but the said facts was not properly proved. The unhealthy mudslinging and character assassination were adopted by both the sides against each other. But the Honorable Mr. Justice Ashim Kumar Banerjee and Honorable Mr. Justice Dipankar Datta, the Honorable Judges of the Honorable High Court, Calcutta Circuit Bench at Cobra in FA number so-and-so, while allowing the appeal on 24/11/2008, were pleased to pass their lordship view that if one is involved in an extramarital affair, which is a social crime, it would hardly be an open affair, and in most cases be clandestine one. It would be difficult for a wife to prove such allegations by adducing witnesses. It is a fact that the defendant, by adducing evidence, failed to establish whether the plaintiff was going to marry or not. But the fact remains that the wife has every right to protect her interests and even the interests of others. Others means if any lady would get married with the plaintiff consequent upon the basis of a decree of divorce passed by the learned district and session judge, Andaman Nicobar, and then that lady has to suffer irreparable loss and injury because of the fact that after the first appeal, the marriage subsists between the plaintiff and the defendant number one by order of the Honorable High Court, Calcutta. As per clause 10 of subsection 26 of the Act, the defendant intend to give caution in good faith to the public, stating that the marriage tie of the
As
plaintiff
per clause 10 of subsection 26 of
Indian Penal Code,
okay.
definition of 499 Indian Penal Code, the defamation, the act has been spelled out, which amounts to defamation. The defendant intended to give caution in good faith to the general public that stating marriage tie of the plaintiff and defendant subsist and the same has not been dissolved by divorce. If some lady being convinced by the plaintiff that the plaintiff has got an order of divorce and enter into marriage tie with plaintiff and that in that even the lady has to suffer immensely. Therefore, the caution notice published in the Daily Telegram on 3rd and 5th December 2008 is nothing but a caution to general public as a whole. This notice was published in good faith without any malice. DW2 and DW3, who knows parties to should have deposed that they had gathered knowledge in the last month of 2008 that Ramchandra was trying to get married with another lady. In cross-examination of DW3, the plaintiff did not put any suggestion that the said witness are deposing falsely or that the witness did not gather any information that Ramchandra was not going to marry. Now, this is with regard to the evidence of DW3 which I have referred to, that there is no suggestion even made to this witness about her acquisition of knowledge about Ramchandra going to marry within the subsequent first marriage. Considering the discussion held in the foregoing para, this court is construed to hold that the plaintiff was not defamed by the publication made by the defendant. Thus, the additional issue disposed of against the plaintiff. Issue number 6 and 7. These two issues are taken up jointly for taking decisions. The most vital issue, that is additional issue number, has been decided against the plaintiff. More so, plaintiff has claimed compensation to the tune of rupees 50 lakhs. The plaintiff has failed to establish how much he has been defamed and how the quantum of compensation has been assessed by him, although he has prayed for decree for the same. In view of the above, the plaintiff is not entitled to get the decree as prayed for and not entitled to get any relief. In view of the above, these two issues are decided against the plaintiff. In sum, the suit fails. CF paid is correct. Hence, it is ordered that the suit be and same is dismissed on contest, but without cost. Now, this trial court judgment was assailed in first appeal. I can show that. Against which this second appeal has been taken out. Page 175. Once I complete this judgment, impugned judgment ownership, then I'll place the relevant provisions of law. I'll take straight away to the reasoning assigned by the first appellate court, right from page 181. Rest are also the facts, the evidence which both the parties have adduced during the trial.
In which page?
Page 181. At the bottom, decision with reason. I'm just placing right from bottom. On perusal of record, it transpires that the present case was initiated on the basis of publication made by the respondent number 1 on 2 occasions in the Daily Telegrams newspaper, which is widely circulated newspaper of this island, having following contents. Now that notice has been reproduced. Note 182, second paragraph. 182, Milord, second paragraph. Because this 181 bottom notice is same. The paper publication which has been reproduced by the first appellate court at page 181 bottom, 182 not right from second pages, the reasoning assigned. The plaintiff claimed that the aforesaid publication, which is separately exhibited as exhibit 3 and 4, was grossly defamatory of him. He alleged that such publication has injured his character, credit and reputation and has cultivated public hatred against him. The principal defense offered by the defendant number 1 is justification. First, fair comment on the matter of public interest. 3, qualified privilege. 183. It is not disputed that the said publication has been made under instruction of defendant number 1, and she has admitted its contents that the said defendant during cross-examination has specifically stated it is true that in my written statement, I've alleged that my husband had an illicit relation with one lady employed in Fort Blair Municipal Council. I did not file any suit for conjugal right. I did not prove the allegation of illicit relationship of my husband. Plaintiff is now aged about 50 years. My son is residing with my husband. I do not know the name of the lady with whom my husband was going to marry. I do endeavor to collect particulars of that lady, but could not succeed, even though I made paper public. She has supported by one Naga Maheshwar Rao, stating that it has come to my knowledge in the last month of year 2008, the said Ramchandra was trying to get married with another lady during the subsistence of marriage between himself and Ananda. Such fact was informed to me by some of my friends. On cross-examination, he stated that I know the defendant for last 20 to 25 years as she is employing under my department. I did not tell the matter to the defendant that I came to learn that plaintiff is going to marry. He has not stated the source of his knowledge or the name of the lady with whom the appellant intends to marry. DW3 in his examination in chief stated that it has come to my knowledge in last month of year 2008 that the said Ramchandar was trying to marry another lady during subsistence of marriage between himself and Ananda. Such fact was informed to her by her friends. She also not stated the source of information. The learned counsel on behalf of the appellant stated that the said witness has stated the name of husband to be late P.K. Roy, but during cross-examination, she named her husband to be Parikshit Chatterjee. Her identity was disputed by plaintiff during cross-examination. I do not find such dispute over identity has any relevance in this case. The plaintiff has supported by
Was supported.
by Mr. Stanley James as PW2. On examination, he stated, I came across an article in the newspaper, namely Daily Telegram, on 3/12/2008, wherein it was stated that the plaintiff is trying to marry another girl in contrary to law, and if such marriage is conducted, the same shall be illegal and unlawful. He further stated that earlier, I used to have very high thinking about plaintiff. After going through the contents of the newspaper, his image was lower down before me. Whenever I faced him, I used to recollect the contents of news item and used to think about him. The said witness is found to be working as lineman in the department of PBMC. In cross-examination, he denied all suggestions put to him. Nothing was asked regarding his appreciation of contents of the newspaper publication. The question whether an imputation or accusation is defamatory or not is a mixed question of law and fact. If there is controversy as to whether the material complained of is a defamatory or not, the court will first have to decide as a question of fact as to whether the said material is capable of being understood in a defamatory sense. If the court decides the question of in affirmative, it will then only proceed to determine whether the said material containing a defamatory potential had in fact harmed the reputation of complainant. Court in every case is required to decide whether or not alleged words are reasonably capable of defamatory meaning, in particular circumstances in which they have been published or spoken. Mukund Martin Chitin versus Madhuri Mukund Chitin, 1992, SEC Criminal 7. Ismail Merchant versus State of Punjab, 1998, Criminal Law Journal 211. The classical definition in the terms given by Mr. Justice Cave in the case of Scott versus Sampson, 1882, Queen Division Bench, 490 is a false statement about a man to his discredit. The said definition has been approved in a series of decisions thereafter. Winfield on torts gives definition. Defamation is a publication of a statement which tends to lower a person in estimation of right-thinking members of society generally, or which tends to make them shun or avoid the person. In the Book of Law of Defamation by Richard O. Civilian, QC, and Ronald Brown, it is stated that defamation may be broadly defined as a false statement of which tendencies disparage the good name or reputation of another person. Thus, a defamation statement is said to be a statement concerning any person which exposes him to hatred, ridicule, or contempt, or which causes him to shun and avoided, or which has a tendency to injure him in his office, profession, or trade. In Sardar Singh versus case Badalia, 1961, 2 Criminal Law Journal 690, it is observed that the reputation has been used to denote the estimation in which a person is set by others, the character imputed to him in the community or the society to which he belongs. A person may not possess property, but still he can have a good character and respectability. Here, there is no dispute regarding the person who is said to have been defamed by the publication made in the newspaper, as he has been specifically named in the contents of the publication. Following are the essential ingredients in order to prove that a person is defamed. The words published must be defamatory. Those words must refer to plaintiff. They must be malicious publications. In the present case, learned counsel for the appellants of the on behalf of appellants submitted that as so far as the caution is concerned, it would sufficient if it is being stated that the decree of divorce so passed by the trial court was being reversed by the Honorable High Court, and the status of the party has been reinstated. But in the said publication, the plaintiff is defamed by stating that it has now been learned from reliable source by Srimati Ananta, wife of Ramchandra, that her husband is trying to marry another girl in contrary to law by which both my client and the said Ramchandra are governed. Such marriage, if conducted, shall be illegal in the eye of law. And marriage, if any conducted, shall not be valid and will confer legal status to girl. I find such statement is certainly uncalled for and is in itself reflects tendency to excite the plaintiff by adverse opinion or feelings of other person. PW2 and 3, who happens to be the subordinate to the appellant, stated that they have come across the article of Daily Telegram newspaper published on 3/12/2008 to learn that the plaintiff is trying to marry another girl in contrary to law. They further stated that they had very high thinking about the appellant, and after going through the contents of the newspaper, his image got lowered before them, and whenever they came across the appellant, the contents of the news items, yes, news items to play in the back of their minds. A statement is judged by the standard of opinion which prevails among the ordinarily right-thinking members of society, reasonable people of time and place. Defamatory words are presumed to be false, as a man is presumed to be innocent, and therefore defendant has to rebut that the presumption by giving evidence of justification. She has to show that the allegations are true. Here, no justification is shown by the respondent. Number one, in her evidence, she neither named any woman, girl, whom the appellant intend to get married. She neither stated that the source from which she learned about such facts. Such statement pointed of the appellant neither can be said to be true or has been backed up by any justification. Such comment cannot be stated to be fair comment, and the respondent number being one being the wife cannot claim privilege of stating same. In common parlance, such statement appears to be published with evil motive, though consideration of motive in law is irrelevant, as an unlawful conduct with good motive will not exonerate the liability. A bad motive in doing lawful action will not cast any liability. According to the law McTaggart, it is an act, not the motive for act, just that we discarded. If the act apart from motive gives rise merely to damage without legal injury, the motive, however, and simply it will not supply the elements. Thus, a malice is totally independent of either intention or evil motive and may include mere carelessness or even a honest mistake. Thus, it can be stated that such words were maliciously published by respondent number one, defaming the appellant, as stated by this court, that such information was not required for public to know and not being done in public interest, as she failed to substantiate her duty to communicate to public and to whom she intended to communicate. I do not find any privileged occasion to make such communication. Thus the principal defense offered by the defendant number one, justification, fair comment on a matter, protecting her interest and qualified period cannot be said to have been substantiated. I find that the portion of publication is to be grossly defamatory to the plaintiff, which has injured his character, credit, and reputation, and has also brought public hatred, contempt, and ridicule. I have no hesitation to hold that the trial court has erred in appreciating the same and has failed to decide the additional issue in its contest. As such, the same is set aside. The plaintiff is entitled for compensation. The issue number 1, 2, 3, 4, 5 are hereby confirmed. There is no method of measuring the money value of the injuries caused by the plaintiff by action of defamation, and the only limit to the damage to be awarded is that they must be reasonable in amount, and there must be some reasonable relation between the wrong done and solution applied. The damages awarded for loss of reputation are in nature of solution and not given either for punishing the defendants or to enrich the plaintiffs. Sheikh Mehta versus Balaji Krishna, AR 1946, and Nagpur 46 at page 54. In order to decide the injury for which the plaintiff should be compensated, the same has been explained by Lord Justice Diplock in 1964 ALI ER as follows. That has been reproduced, Lord. Page 199, Lord. The plaintiff claimed in the present suit for general damage of 50 lakhs on the ground that the plaintiff has been injured in his character, credit, and reputation in this way of life and has been.
Which one you are placing?
Not page 189, second paragraph.
Plaintiff claimed in the present suit.
The plaintiff claimed in the present suit for general damages of 50 lakhs on the ground that the plaintiff has been injured in his character, credit, and reputation in his way of life and has been got into public hatred and contempt and ridicule. In the instant case, it is already held that the respondent number one has defamed the appellant by publishing certain words in a daily newspaper on 2 occasions. The appellant is a qualified engineer holding a high office in the government organization, and the respondent is also a government employee. The appellant has claimed that such publication has damaged his reputation and his status in the society, and he has also been embarrassed when his son, who is residing with him, has inquired from him about such marriage. The plaintiff entered into the witness box to show his extent of his diminution and the extent he is avoided by his colleagues or shunned by his associates. PW2 and PW3 has also placed their opinion about plaintiff before and after such defamatory publication. Thus, considering the personality of the plaintiff and finding him to be a sensitive manner and considering that he has undoubtedly suffered mental distress due to such publication, I have no hesitation to assess 2 lakhs towards damages so suffered by him due to such defamatory publication caused by defendant number one. Defendant number one oblique respondent number one is liable to pay damages to the plaintiff within 90 days from the date of passing of the judgment. The question of granting interest came in case of namely Union of India versus MS Mahal, 1976 GNKT. It was held therein that the interest is payable from the date of claim and not from the date of order. Relying on this judgment, Jammu and Kashmir High Court in Union of India versus Miss Savita Sharma, AN 1917 JK, held that claims tribunal is erred in allowing interest from the rate of order and not from the rate of his claim, and therefore allowed interest 6% per annum from the date of claim. In obedience with observation made by the Honorable Court, I do not have any hesitation towards 6% per annum in addition to awarded amount from the rate of filing of the present suit, that is 119/2000. The impugned judgment and the decree passed by the trial court in other suit number 1 of 2009, renumbered as other suit number 33 of 2012, is hereby set aside. The other appeal is allowed. In result, it is accordingly ordered that other appeal being number 30 of 2014 be and same is allowed on contest without cost. The respondent number one is hereby directed to pay rupees 2 lakhs towards damage to the appellant herein, along with the simple interest of 6% per annum from 1/1/2009 to 9 till realization of the amount within 90 days. So this was the finding of the first appellate court while setting aside the judgment of learned trial court. Now this court, while admitting the second appeal, formulated 2 questions. One would find those 2 questions at page 203. Of the paper book. The appeal shall be heard on the following substantial question of law. 1. Whether a publication that the appellant is legally wedded wife and no lady should contract the marriage with the respondent amounts to stigmatizing the reputation and prestige of the respondents before the general public. Second, whether the Court of Appeal below was justified in quantifying the damage in a suit for libel without there being any material justifying such damages to be awarded against the respondent. Now, this appeal needs to be heard out of these 2 questions. First of all, question number 2. Lord, before I substantiate my prayer, my Lord needs to see Order 26, Rule 9 of the Code of Civil Procedure. Normally, as a lawyer who practices in this island, think, my Lordship, Order 26, Rule 9 relates to an immobile property, local investigation. If my Lord sees that, under Order 26, Rule 9, the damages can be quantified. Assessment as regards damages, if there is a dispute with regard to the assessment of damage, that can be quantified invoking Order 26, Rule 9, which in the present case was not done. I'll just show that. Just one second. Order 26, Rule 9. I'm just praising. It's yes. Commissioner to make local investigation. In any suit, the opening sentence is not in any suit. The nature of suit is hardly matters. In which the court deems a local investigation to be requisite or proper for purpose of elucidating any matter in dispute or of ascertaining the market value of property or the amount of mean profit or damages or annual rent, the court may issue a commission to such person as it think fit, directing him to make such investigation and to report thereon to the court. Now, in course of in terms of this Order 26 Rule 9, even the issue as regard quantification of damages can be gone into by a court. The plaintiff before trial court did not take any steps, neither even any application has been made inviting a trial court to assess this aspect. 50 lakhs, 5 lakhs, 2 lakhs, hardly matters. Be it 1 rupee, be it a single penny, my lord. If it is a suit in simpliciter claiming damages, then the court's left open to one who asserts, one who wants a court to pass an order in such a suit has to invoke this provision. Leaving aside this, my lord. As I've said, my lord, normally we think Order 26 Rule 9 and Order 39 Rule 7, we makes an application in an immovable property only. Superficial inspection, Order 39 Rule 7. If investigation is to be done, Order 26 Rule 9. But under Order 26 Rule 9, even this exercise can be done by a trial court. Even this power, Lord knows, even this power could have been exercised during the pendency of the first appeal also, because appeal is the continuity of the suit. Even the respondent, the present respondent, who was the appellant before the first appellate court, did not took this remedy. No remedy was, the remedy was available to the appellant of the first appellate court, plaintiff of the suit. So only the division bench of this honorable court, while admitting the second appeal, while formulating the second question, have framed this question. But even leaving aside this, even the material which were placed before the trial court by the plaintiff justifies any amount to be paid in the form of a damages, save and except two evidence who happen to be the parrot witness who have in tune with what PW1 have said deposed before the court below. That we read it, two publications, we have formed an opinion. The reputation of plaintiff has been vilified. Straight away plaintiff claims 50 lakhs I want. Lord, Exhibit A, the solemn judgment of the division bench in the matrimonial proceeding, and the said judgment being affirmed by the Honorable Apex Court, I would place the judgment once my adverse side completes. Lord clearly indicates that the plaintiff of the present suit was having an extramarital with that lady. I have named the lady. I have shown my written statement. And the Honorable Court has clearly said this sort of relationship, extramarital, Lord, it can't be open one. If Lord reads between the line of the solemn judgment, one thing is very clear, the foundation to get a decree of divorce on this character assassination the Honorable Court has deprecated it. Taking into account my pleading, giving the name and the conduct of the respondent herein, husband. So I'm coming to the first question. So the second question, how the first appellate could have gone into Milosh, I'm asking myself. Where from this
How the
first appellate could have arrived that I have to pay 2 lakhs? How this amount has been calculated? I would say it's a mathematical calculation without any backed up with any substance. There has to be some concrete evidence. When an appeal is filed under Order 41, being in continuity of the original suit, the parties are not precluded. The procedures which are adhered to in an original suit is always available to the parties. This remedy was.
So according to you, you have twofold contention. One is that you have named the woman according to whom, according to you, with whom your husband was going to marry.
Yes. Who maintain extramarital.
Going to be married.
Yes.
Once again. First contention, and the second contention, and banking upon this contention, you state that there is no defamation.
Yes, no. There's no defamation per se. There's no defamation motion.
First of all, this is
My
the
lord.
main contention.
My lord.
And in addition to that, as regards to quantification,
Yes.
no proper procedure has been adopted
Yes.
by the court
My lord.
for coming to the conclusion that rupees 2 lakhs.
2 lakhs.
These two contentions.
Yes. I'm going reverse, Lordship, because I'm going with the second contention, because if I argue second contention firstly, then may not take it that I've admitted the claim. I never admitted the claim. So only I've taken out the second appeal. But the question has been formulated by the division bench.
No, that's why I'm
saying. My
lord. Your first contention is that you have named the person with whom your husband was going to marry.
But not in the publication. I have not named the girl. I simply said it's a caution. I'm giving a general public awareness that since already High Court in decision of an appeal have reversed the decree of divorce, and as the relationship subsists as a husband and wife, no one would dare to marry my husband. How this words, everything is, the words are, jugglery of words needs to be seen. I will draw my lords to those publications, the word used, deployed, it would not in any way tarnish the reputation of my husband. In no way. It's not such a case. It's not the nature of such case where a suit for damages could have been filed. It's not such a case where the first appellate could have granted the amount in favor of husband, directing me to pay it. It's not such a case.
Yes, Mr.
The first question, the vital question, the pivotal question, which goes to the very root of the matter, is whether a publication that the appellant is legally wedded by and no lady should contract the marriage with the respondent amounts to stigmatize the reputation and prestige of respondent before general public. My lord, for that, my lord needs to look into those publications once again. At the cost of repetition, I would draw my lords to come to exhibit 3 and 4. Those two publications, my lord would find at page 105 and 107 of the paper book.
105.
Five. First, if I show one, the second one is same, replica, 105, my lord.
Yes.
Look, if my lord sees, I'm just placing again. Under instruction from my client, Srimati Ananta, wife of Sri Ramchandar, it is brought to the notice of general public that my client's husband, Sri Ramchandar, son of late Jeevan, residence of Machiline, who is presently holding the post of assistant engineer under the Port Blair Municipal Council, Port Blair, filed a matrimonial suit, being MAT suit number 27 of 2005, before the Court of District Judge, Port Blair, praying for decree of divorce against my said client on the alleged ground of cruelty and desertion. On 14/7/2008, the learned District Judge Port Blair allowed the divorce petition of Sri Ramchandra, thereby dissolving the marriage tie between Ramchandra and my said client, Srimati Ananta, wife of Sri Ramchandra, challenging the said judgment and decree dated 14/7/2008. My said client preferred first appeal, being FA number 03003 of 2008, before the Honorable Division Bench of Honorable High Court at Calcutta, Circuit Bench at Port Blair, which ultimately was allowed on 24/11/2008, whereby the Honorable Court was pleased to allow the appeal of my said client and thereby set aside the impugned judgment of the decree and dismiss the suit filed by the said Ramchandra before the learned district judge. Now, it has now been learned from reliable source by Srimati Ananta, wife of Sri Ramchandra, that her said husband is trying to marry another girl in contrary to law, by which both my client and said respondents are governed. Such marriage, if concluded, shall be illegal in the eye of law, and the marriage, if any, conducted shall not be valid and will not confer legal status to this girl. My lord will not find in this publication any word, any libelous word, which would literally defame my husband. Why I publish this, my lordship? This is based on the finding of the Honorable High Court. I have given just a notice. This is based on the finding of the High Court. If my lord looks into the Honorable High Court's order in the family dispute matter, the court has come to a conclusion. I could have understand if in this publication I have made imputation that my husband is having an extramarital affair. I could have understand that. Even in such a case, it would not amount to defamation, but to some extent, the court can consider it. How could I say that? Because my husband is also a human being. He has right to live with all honors in this society, my lord. Those things I can know. But the words which were deployed in this publication, I have borrowed these words from what the High Court had said while reversing the decree of divorce. So in no way, not cease the read between the lines. Not even a single word in any manner would tarnish the reputation of my husband. In no way, my lord. Even if these lines are not there, my lord, even if this caution notice is not there, what I am trying to convey to the public remains. If I use unparliamentary words against my husband, I can understand. It's a defamation per se. Even my lord would not find any such word. So only the division bench has formulated the question number 1, whether ex facie this publication create any stigma. My answer would be no. And how the first appellate court dealt with this issue, my lord, and the judgments which the first appellate court has relied to come to a conclusion, yes, it's per se defamation. No, I will show, my lordship, I will cite judgments also. Those judgments which the first appellate court have relied is in a different context. My lord knows a slightest difference in facts would make lot of difference in authority value.
Yes, Mr. Jaipal, now the citations.
My lord, I will give it, my lord. I will give it once madam completes, because I have a right to reply on law point.
Yes.
My lord knows it.
You have the right to give reply on the law
Law
point
points,
only.
absolutely.
At that time, if you adduce the citation, then she will also say that.
No, the reply,
For
they
the
can't be reply to reply. My lord, not knows it. They can't be reply
That's why,
to.
that's why give the citation.
No, I have those things I have prepared it. I have not brought it. I
Those
can
are, those are required to. be
because I've
prepared.
started today.
So prior to her submission,
I will place it.
place the
Absolutely,
citations.
absolutely.
Thereafter,
Yes, my lord, yes.
and thereafter you will get the opportunity to give reply only on the point of law.
Absolutely. No facts, Don. Yes.
Anything more?
That's all. That's all. That's all.
So the main contention is yours is that there is no unparliamentary word,
Yes.
no words have been stated or uttered there, which goes against the husband
My lord.
and which is defamatory or tarnishing the image of
My
the
lord.
husband.
My lord.
All that is stated are the facts in sequence.
My lord. That's it.
Name.